Good morning, good afternoon, and good evening. Welcome to Seminar A of the Monique and Roland Weil People's Academy of International Law. I am Marjorie Cohn, Dean of the People's Academy of International Law, and a member of the Bureau of the International Association of Democratic Lawyers. In our last program, Course 2B, we discussed the United Nations organs, their respective roles and competencies, and compliance with international law. Our next program will be Seminar B on March 21st. It will cover unilateral coercive measures and their illegality. The faculty will include Nina Farnia, Prabhat Patnaik, and Charlotte Cates, and you will all be sent a Zoom link. Our topic for today is the right to a clean and healthy environment. Our faculty for this seminar includes Martha Schmidt, Mametlwe Sebei, and Richard Harvey. Each of them will speak for about 35 minutes, followed by a discussion between the faculty members, and then we will have questions and answers with the registrants. We have French, English, and Spanish translation. And at the bottom of your screen, you can choose your language. Please put your questions in the Q&A box for our discussion following the presentations. In the next few days, we will post the faculty presentations in English, French, and Spanish on our website, peoplesacademy.net. And now I will tell you about our esteemed faculty. Martha L. Schmidt is a member of the task force of the People's Academy of International Law. She has an LLM in Law and Marine Affairs and a JD and a Master's of International Administration. Marty co-chaired the Human Rights Framework Project of the National Lawyers Guild, and she was a board director of the Center for World Indigenous Studies, and she advises National Single Payer and other U.S. groups working on the human right to health. In the past decade, Marty helped organize the movement for the human right to health care in the United States. She practiced labor and equal employment law in Washington State, and she chaired the World Peace Through Law section of the Washington State Bar Association, where she led a successful effort to get the association to support U.S. ratification of the Convention on the Rights of the Child. That's the Bar Association, not the United States, which of course we know has not ratified the Convention on the Rights of the Child. Marty served as regional vice president of the National Lawyers Guild, and she co-chaired its subcommittees on peace and disarmament, the occupied Hawaiian Kingdom, and the task force on the Americas. She also served as director of an anti-nuclear organization. She was a union organizer, a labor rights educator, and she taught human rights, public international law, and the sociology of social movements at the University of Washington and the Evergreen State College. Marty will provide a history and overview of the right to a healthy environment. Mametlwe Sebei is a lecturer in the Department of Jurisprudence at the University of South Africa, an attorney at the Lawyers for Human Rights, and course instructor of Just and Green, Labor's Ecological Question at the Global Labor University. He serves as president of the General Industries Workers Union of South Africa and is a member of the National Executive Committee of the South African Federation of Trade Unions. He is also a member of the steering committee of the Climate Justice Coalition. Mametlwe is affiliated with the International Socialist Alternative, where he has served in national and international leadership for 15 years. He has been organizing workers since 2008. He coordinated the 2012 mine workers' strikes following the Marikana massacre and Outsourcing Must Fall that was part of the university student movement, Fees Must Fall. He also served as national president of the Pan-Africanist Student Movement of Azania and deputy president of the Student Council at the University of Pretoria, as well as national SRC at the University of South Africa. Mametlwe earned his BA in law at University of Pretoria, his LLB at the University of South Africa, and his master's in sociology at Wits University. Mametlwe will discuss Just and Green, a labor perspective on the right to a clean, healthy, and sustainable environment. And our final speaker is Richard Harvey. Richard is legal counsel for campaigns at Greenpeace International. He focuses on climate-related strategic litigation, promoting the human right to a clean, healthy, and sustainable environment. He works in particular on adverse impacts to peoples of the global South caused by global North corporations and governments. He and his colleagues strive to protect the environment for present and future generations. Most recently, Richard appeared on behalf of Greenpeace in Klimasignorinen versus Schweiz, the Swiss Climate Senior Women versus Switzerland, before the Grand Chamber of the European Court of Human Rights. This is the court's first ever hearing on human rights obligations of states for threats posed to their peoples by climate change. Richard is a barrister in England and Wales since 1971, a member of Garden Court Chambers London. He served as an attorney at the New York Bar from 1982 to 2000 and was lead counsel at the International Criminal Tribunal for the former Yugoslavia from 2007 to 2014. He has worked in Greenpeace International's legal unit since 2014. Richard will discuss the global demand for climate justice. So with that, we will begin. Marty, you've got the floor.
First slide. Next slide. So I'm going to be talking about human rights and the human right to a clean, healthy, and sustainable environment from the standpoint of the development of this collective right. First of all, I think that it's quite apparent that this right is a challenge to our nation-state-based system of public international law. Also, I want to refer to this right as the right to a healthy environment, which is a little bit shorter and actually is often used. And I believe healthy includes clean and sustainable if we really think about it. A collective right means that claims are aggregated on behalf of an entire group. Now, this group is generally perceived to be the people who live in a state. But I ask you, how meaningful are national borders to the right to a healthy environment? The duties that a state has go to its citizens, its residents, and others under its jurisdiction, and to the entire global community, erga omnes. As is the case with all human rights, the purpose of this collective human right to a healthy environment is to promote human dignity. The right to a healthy environment is interdependent with other collective rights. particularly to self-determination of peoples, the right to peace, the right to sustainable development. The right to a healthy environment is also interdependent with individual human rights, among which are the right to life and the right to health, including to health care. It's a well-established principle that all rights, collective, individual, group, whatever, are universal, indivisible, interdependent, and interrelated. This notion comes from the World Conference on Human Rights in Vienna in 1993. It's, I think, obviously clear that decolonization is necessary for the world to realize the right to a clean, healthy, and sustainable environment. And of course, we're talking about colonialism and neocolonialism. It's helpful to have a vision of what this struggle involves. And I call your attention to The Nutmeg's Curse, Parable for a Planet in Crisis, written by Amitav Ghosh and published in 2021, which is a study of the intersectionality of colonization, the environment, and war. One thing he says is that the European muting of a large part of humanity cannot be separated from the simultaneous muting of nature. That is, to extract economic value, turn humans into slaves and servants, and their environment into commodities or mere resources. This requires a belief in natural laws that some species are condemned to extermination or extinction. This is where we find ourselves still. I also call your attention to the book by Sven Lindqvist, Exterminate All the Brutes, and to Ghosh's view of that as referring not only to the humans, but also to all other species. That is, exterminate all the brutes means both genocide and omnicide. Next. The right to a healthy environment, of course, also challenges the powers who control the global political economy. I'm sure others will be talking about this, but clearly our global political economy is characterized by gross disparities of wealth and power resulting from colonialism, neocolonialism, and imperialism. And this disparity, not surprisingly, is closely related to carbon emissions. Especially in the US, the approach to working for the right to a healthy environment has focused on individual and moral politics, such as be the change you want to see. But while these may be gratifying, they really do divert from a focus on systemic change. It's clear that both capitalism and political military dominance are obstacles to realizing the right to a healthy environment. And therefore, what we need is collective decision-making, a preference for public good, human rights guaranteed by public authority, including authority of indigenous nations. And as a start, we need to reverse privatization. Next. I'm going to give a very sketchy recent history, which is 50 years now, so it seems longer than recent, of some steps that have taken us to articulating the human right to a healthy environment. We've had the UN-sponsored process of conferences and treaties We've had resolutions of the UN General Assembly and the UN Human Rights Council. There's been the creation of Human Rights Council special procedures and experts. And we had, importantly, the UN independent expert, now the special rapporteur on human rights and the environment. We also have some related experts and rapporteurs on environmental matters, including a special rapporteur on toxics and human rights, and a special rapporteur on human rights and climate change. We've also seen regional human rights treaties and protocols and decisions of regional international judicial bodies. Some of the milestones that I just like to mention are the 1972 Stockholm Declaration and Principle 1 of that, which has to do with the right to a healthy environment. The 1981 African Charter on Human and People's Rights, which in Article 24 protects the right to a healthy environment. The World Charter for Nature, a UN General Assembly resolution, and the UN Convention on the Law of the Sea in 1982. The 1987 General Principles that the Experts Group on Environmental Law of the World Conference on Environment and Development developed. The San Salvador Protocol of 1988, that was the additional protocol to the American Convention on Human Rights in the area of economic, social, and cultural rights, and particularly Article 11. We also, of course, have the 92 Rio Declaration on Environment and Development and other agreements in the Americas, including the 2018 Escazú Agreement, which deals specifically with access to information, public participation, and justice in environmental matters in Latin America and the Caribbean. And then besides the Human Rights Council resolution, we have arrived by 2022 at the stage of having a resolution from the General Assembly on the right to a healthy environment. Next. Some of the key individual human rights instruments that are related to the right to health and to a healthy environment are the Universal Declaration of Human Rights, particularly Articles 25 and 28. 25 is the right to a standard of living adequate for health and well-being. Article 28 entitles everyone to a social and international order in which the rights of the Universal Declaration can be realized fully. The 93 Vienna Declaration and Program of Action provides interpretation on the rights that everyone enjoys under the Declaration and the covenants. There's also an earlier provision of the World Health Organization and its constitution. Its prime principle is the enjoyment of the highest attainable standard of health. The World Health Organization calls this one of the fundamental rights of every human being, without distinction of race, religion, political belief, economic, or social condition. Of course, the covenants, the International Covenant on Economic, Social, and Cultural Rights, and the International Covenant on Civil and Political Rights provide key protections for the rights to health. Article 12 in Economic, Social, and Cultural Rights Treaty and right to life in the Covenant on Civil and Political Rights. There's also the common Article 1 of the two covenants, which protects the collective right to self-determination as a precondition for the realization of individual human rights. Then I think it's interesting that the International Convention on the Elimination of All Forms of Racial Discrimination, in its Article 5, provides the right to public health, which expands in some ways the notion of the individual right to health. It pushes it more towards the collective. Next. The right to a healthy environment has also been developed by expanding the human rights of indigenous peoples. Obviously, these have to do with the right of self-determination, the collective right of self-determination. There have been two declarations, one by the United Nations, the other by the Organization of American States. The 2007 UN Declaration has 4 articles at least, which have much to do with health and a healthy environment. For example, Article 24 talks the same language as we've seen in the World Health Organization Constitution, the rights to the highest attainable standard of physical and mental health. But it also adds the right to traditional medicines and practices and adds health services. Article 25 of UNDRIP refers to the spiritual relationship with lands, territories, and waters, and to uphold responsibilities for future generations. That is, turning the right into a duty. Article 29 provides a right to conservation and protection of the environment and to protection from hazardous materials. Both Article 29 of the UN Declaration and Article 19 in the American Declaration specify the right to live in harmony with nature and a healthy, safe, and sustainable environment. The harmony with nature is an important principle that has evolved along with the development of the right to a healthy environment. Furthermore, these declarations give protection to cultural heritage, particularly intellectual property rights, such as seeds, the rights to all systems of healthcare, and importantly, the civil right to free, prior, and informed consent and prohibition on biological research. Another development that has been really important to expanding human rights of indigenous peoples that's closely related to the right to a healthy environment overall development is the jurisprudence of the Inter-American Court of Human Rights, which has used both hard and soft law to link the American Convention on Human Rights, the individual rights under that, such as non-discrimination, the rights to basic services, cultural identity, and property, to protect collective well-being of indigenous peoples in their environments. And one of the notable accomplishments of the court has been articulating the doctrine of the inherent right to property and the idea of common property to protect land and resources for future generations, really switching the role of property, which is sometimes and not infrequently actually in opposition to human rights, but the court has managed to switch the way it treats property into a recognition of a biocentric role for property. And this case from Nicaragua, from Asumo from 2001, was really important to that development. Next. There's also a whole line of legal authority that aligns the right to a healthy environment with the another collective right, the right to sustainable development. There's the Sustainable Development Agenda adopted in the General Assembly by General Assembly resolution in 2015, and what are called the 2030 SDGs, Sustainable Development Goals. And those include particularly the 1 through 3, 6, 12, and 15, which have to do with the rights to and poverty and hunger, promote food security, promote good health, provide, manage, and sustain fresh water and sanitation, to sustainable consumption and production, taking action to combat climate change, conserve oceans and sustainable use of marine resources, and protect territorial ecosystems. All of those areas are subjects of sustainable development goals. There's also, as I mentioned, the development of the notion of harmony with nature, and there's a 2018 General Assembly resolution, which talks about the integration of economic, social, and environmental dimensions of development. Then there is the constitutional or national developments, and I'm just mentioning a couple of those. What I'm referring to as Buen Vivir amendments to the constitutions of Ecuador and Bolivia. But the idea of living well, a cosmovision of an ideal life that's fundamentally different from a Western progress, modernity, development ideology that is of humans as part of nature, and the inseparable connection between the material life of reproduction and production and social and spiritual life. There's also amazing lawmaking and visionary work going on all around the world on the rights of nature, the rights of ecosystems in metropolitan law and national law. Since 2006, there's at least 35 countries, probably more than that. But I'm just referring to this white paper that was presented at COP28, which took a little look at some of the developments and what they do, these movements. And I've been part of one trying to get person status for the orca here in Washington State, is to confer personal status on other beings in order to protect them from being extinguished, damaged, polluted, destroyed. And the kinds of rights bearers that are out there besides humans include rivers, areas threatened by mining, individual lakes, the Great Lakes, lagoons and their basins, forests and trees, waterways, plants such as wild rice, corn, wildlife and their habitats, salmon and orcas, valley and cloud forests. It's really quite astonishing when you think about this as a popular global movement in all its variety. trying to basically take on the Western concept of property relations in many different ways. Next. There's also the advisory opinions of international courts, which have been asked to clarify the right to a healthy environment and state duties often. And one that has already happened is the Inter-American Court of Human Rights advisory opinion in 2017, which is the first recognition of the human right to a healthy environment in a judicial setting, international judicial setting. And it recognized both procedural rights as well as the connection between climate emergency and the right to a healthy environment, and held that the obligations pertain to all states, despite it having been brought only by a couple of states. So reinforcing the erga omnes obligation. There's also pending requests for advisory opinions. Amazing, a lot of them. One, the small island states have submitted a request to the International Tribunal for the Law of the Sea on climate change and the law of the sea. There's an amicus brief that was filed by 3 of the UN special rapporteurs on this. There's also a request by Chile and Colombia to the Inter-American Court of Human Rights from January 23 on the scope of state obligations for response to climate emergency under human rights law. So that's following up on the advisory opinion of 2017. Then there's the General Assembly request to the International Court of Justice on state obligations concerning climate change. Next. So I just want to talk a little bit about some what I consider to be interesting creative legal strategies to address climate disruption and some other of our environmental crises. For example, just recently, just a week or so ago, there was a hearing before the Inter-American Commission of Human Rights asking for the commission to recognize forced displacement of people as a consequence of climate disruption and for guidance on the rights of internal and external migrants. And of course, this is to address the terrible levels of criminalization and refoulement of migrants that are happening, not just by the United States, but globally. Another really interesting development is the drafting of the Antarctica Declaration. And the purpose of this has been to strengthen and expand the 1959 Antarctic Treaty to align human rights with the rights of our non-human kin of natural beings, and linking those human rights with the health of the earth. It's interesting to see the complementary legal regimes and how the drafters have invoked the principles of harmonious coexistence, prevention, precaution, interdependency, prohibition on military activities, and prohibition of exploitation of resources and ownership. And as I think everybody's probably aware, that Antarctica is outside any state jurisdiction, but it is subject to increasing encroachment from tourism, extractive activities, especially overfishing, and the potential for mining. And as we all know, the poles, but especially Antarctica, is extremely vulnerable, and the loss of Antarctic ice as a contributor to sea level rise affects all of us. Next. Another creative legal strategy has been the involvement of scientists, environmental policy experts, and human rights experts to draft a universal declaration on the rights of wetlands. And this is proceeding in partnership with the UN Department of Economic and Social Affairs, Sustainable Development. What it also attempts to expand the 2018 Ramsar Convention on Wetlands, which, like the Antarctic Treaty, has not been successful in saving wetlands. And what the drafters of this instrument are doing is to try to shift the paradigm using the Universal Declaration of Human Rights to include universal rights for nature. So some of the rights that are included in this declaration are the right to exist, which of course is like the right to life, to ecologically determine location in the landscape, to sustainable hydrological regimes, to sustainable climatic conditions, to have naturally occurring biodiversity, integrity of structure, function, fulfill ecological role, to freedom from pollution, and the right to regeneration and restoration, which of course is an equitable concept and a concept related to future generations of life. Next. I wanted to also mention that using human rights analysis, particularly the rights to health and to a healthy environment, we can see that the analysis of the duties that are involved in the collective right to a healthy environment involve similar elements as for individual rights, such as universality, non-discrimination, and equity. For example, the right to health care, which of course is closely related to the right to health and the ability, the capacity of all individuals on the earth to actually cope with the changes in the environment and the disruption. This right requires universality, that is, universal access. No cost barriers to use, free at the point of access. It requires comprehensive goods and services, available infrastructure. These have to do with equality issues of collective rights too. Equity is a principle of the right to health care. And that, of course, means that those who have greater need or a history of social deprivation have a right to have that need met. And the no discrimination principle based on status. This is, of course, throughout all of UN articulated human rights and elsewhere, not just UN, but very important. And the non-discrimination provisions have to do with both procedural and substantive equality, unlike US law. Then, of course, there's the highest attainable quality standard to achieve physical and mental health, which we see repeated throughout all these instruments affecting both health and healthy environment. And those civil rights that pertain to the ability to exercise and to participate in the struggle, rights to receive information, participate in decisions, access, of course, to legal remedies when systems fail, which inevitably they will. Next. So I've talked about universality, and that obviously requires eliminating barriers. I think one question that comes up, for me and for many of us, I'm sure, is the the interdependence of the right to health and the right to a healthy environment as framed in the problem of air pollution. It's estimated that 7 million people will die per annum from illness caused by air pollution, highest single health impact. Obviously, both the rights to health and a healthy environment are interrelated here, and you can see how these principles would apply in many complicated but necessary ways. Next. So I just want to mention these basic principles, which those of you who might be interested in getting into or doing more active work in the area of the right to a healthy environment would be good to be well versed in these as part of your toolbox. One, of course, principle that's very important and longstanding is the duty of cooperation. And you can see this in the UN Charter in Article 1 and in 55 and 56, which address human rights. Of course, there's the principle of prevention of environmental harm and the principle of precaution, of adopting measures despite the lack of complete information in order to avoid danger. There's the principle of polluter pays, which, as we know, doesn't get honored very often. The principle of using best available scientific knowledge, the idea of non-retrogression from treaty obligations and commitments, that is, no walking backward, reneging on obligations that have been undertaken by states. I'll just make a special note that that is something that the U.S. is commonly engages in. The principle, of course, of equality and non-discrimination, intergenerational equity, and differentiated obligations as between states, depending on their role in creating environmental harm. And I will say that a lot of these ideas, these principles also are connected up with notions of equity. And I have been thinking about how equity is perceived, particularly in the US, and why principles that rely on equity are very difficult to struggle for here, and even to it's a huge ideological challenge too. But I want just to raise that because I think it's worthy of discussion later. Next. So these are just, I'm going to leave you with some of the framework principles that the special rapporteur has developed as guidance for the obligations of states. And these are accepted by the UN Human Rights Council in its resolution. And they're also referenced in the General Assembly resolution in 22 on the human right to a clean, healthy, and sustainable environment. So I think we can say that these, regardless of whether they're soft law at this point, they're en route to being globally accepted. So the framework principles 1 and 2 have to do with ensuring a healthy environment in order to fulfill individual human rights and ensuring individual human rights in order to ensure a healthy environment. That is this whole notion of the interdependence of the individual and collective right. 3 and 4 deal with prohibition against both direct and indirect discrimination and ensuring effective protection against discrimination, and enabling a safe environment for individuals and groups who are human rights defenders, which, as many of you know, has been a huge challenge given the retaliation against human rights defenders. Next. So Framework Principle 5 addresses some expressive, associational, and assembly rights in relation to environmental matters. So civil rights that pertain to realizing the right to a healthy environment. 6 and 7 also have much to do with those civil rights, but include more focus on education and communication, and what might be also considered a duty to collect, a scientific duty to collect information to facilitate protective measures. And finally, there's a public education component in these 2 principles too, that the right of people to have affordable, timely access to environmental information, which of course is critical. And Framework Principle 8 has to do with environmental impact assessments, which many people are familiar with, but the duty is also to have the assessment look at the human rights effects of projects and policies, which is not incorporated into much of environmental impact assessing. The Framework Principle 9 calls for early public participation in decision-making, including marginalized peoples, justification for decisions, considered decisions, decisions made public. So this has to do with a democratic process of decision-making, essentially. Next. The principles 10 and 12 are related to providing effective remedies for violations of human rights and providing good domestic laws relating to the environment. And of course, mentioning that the enforcement has to be against both public and private actors, and invoking the guiding principles on business and human rights, which are still not adequately developed. And then 11 is to provide substantive environmental standards that are non-discriminatory, non-retrogressive. So that really has to do with a full realization by all appropriate means. So deliberate, concrete, targeted measures, using the best science and using effective measures to prevent harm, the precautionary principle. Next. What I want to leave you with is just some questions about the framework principles, and for that matter, the entire human rights and environment system. Some concerns that I have and areas that I think are worthy of our further discussion and communications. One is the weak and facilitating approach to privatization and the acceptance of commodification of human rights throughout the UN system, and the very tepid calls for governments to regulate private actors and requests for business to comply voluntarily. I mean, I think this is related to corporate capture and worse. And now the phase of capitalism that we find ourselves in, dominated by finance, capital, insurance, real estate, the financializations phase that Michael Hudson and Radhika Desai have so ably described, is taking us even further away from an ability to regulate private actors. So this is a huge concern I have with the approach that has been taken so far. Also, as I alluded to earlier, the mechanisms to address the rights of migrants, the human rights of migrants, that is, people caught between states because of climate disasters and other environmental crises. We don't really have in this state-based international law system the kinds of mechanism that really protect people who are not fully within their own states. And so I think this is another area that we'll have to think about a lot more in terms of the right to a healthy environment and the conditions of humans in migration. And then, of course, a huge area that's missing is an evidence-based assessment of all military activities, their impacts on the environment. All of these principles need to be invoked to assess and address military activities, and especially, I think, for the US, which has not been subjected to the proper scrutiny. I thank you.
Thank you so much, Marty, for that really comprehensive context and history and listing and evaluation of the human rights instruments, the international instruments that set the stage for the rest of our program. Next, we will hear from Mametlwe Sebei. Mametlwe, take it away.
Sorry. Thank you, Marjorie, and the facilitators and the participants in the program. I have the notes here that I've compiled, and I think I'm only going to be touching on the most important points. And I think these notes will be up along with the material that I think should be able to guide further study of this subject. But I think the most important point to make is that where I think the previous speaker highlighted about the development of the right, I think from the legal point of view, having to bring labor perspective on this, try to look at the historical evolution of that right, for me, as a conquest of the struggle of the working class. And I think that means, firstly, looking at, why this question, is coming back today, but also how it developed historically, and I think, because that history has rich lessons for the movement today. And I think is much more important in a context where for many young people radicalized by the climate change and entering the movement for the first time may be despairing, particularly about the role of the workers' movement, which I argue it remains central to the struggle for environmental justice and the struggle to overcome the crisis of climate, of environment, but also, I think, all other crises of capitalism. And I think for me, it is important to make this point in terms of the approach that I'm taking here. So I'm arguing that basically the environmental question, or rather the right to a clean, healthy and sustainable environment, as I've said, is a conquest of class struggle historically. And I think this right is relevant insofar as the working class, the environmental justice movement has a power, not only to attain it as a have, and now they've secured its entrenchment in law, but also to be able to defend it against the constant attack and so on, from the corporate interest, and of course, the political establishment in service of those particular interests. And I think also to say that these crises need to be located within the broader crisis of capitalist system, because, you know, for us as a workers' movement, a climate and environmental crisis is but a manifestation of the broader crisis. So I'll also be looking into that. And I think also, you know, how the movement dealt with this question originally, how the movement its position has shifted, but also what can be done to reforge the historic ties between the struggles of the working class people and, of course, the struggle for a right to a clean, healthy, and sustainable environment. So the point I think to emphasize in the discussion is, you know, to impress on our participants here, you know, the significance of this crisis, and to make the point that we are really living through one of the most turbulent periods in history. And to underline the fact that whilst the turbulence, the crisis are not really unique in this period, I mean, unique to this period. We've had crises before, but what we are facing with, unlike before, is not just, you know, a passing moments of immense suffering and acute crisis as we had, you know, in the world wars of the 21st century, or you could even argue that, I mean, ongoing bloody carnage in Gaza, which we could be sure it will come to pass one or later. What we are confronting, particularly in terms of the ecological crisis, environmental crisis of capitalism, is really a civilizational crisis. And arguably, I think, comparable, if you like, with, you know, collapse of major civilizations, the past, Pax Romana and other great civilizations of antiquity. But even there, I think the depth and the scope of the current crisis, or of those crises and collapse of civilization were still modest in comparison, because these are civilizations that were only, or that only cover some parts of the world. Never even a quarter never even a quarter of the planet at any given point in time. Capitalism, in contrast, has created a truly worldwide civilization for the first time in the whole history of our species. And its crisis is truly a worldwide, crisis facing the whole of humanity. And in the situation where what we are faced with is really a deep organic crisis that manifests itself in almost every facet of life and across every region, it threatens the very foundations of human civilization. And indeed, when you take, the threats that are posed, our very existence as well. I mean, the growing threat of nuclear war, the deepening crisis of climate change are just the two sharpest and the most acute expression of this crisis. But I think we can also say that this crisis is tearing the fabric of society apart and has placed the very survival of humanity in question. And I'm going through this to underline the fact that it can't just be that we look into the crisis, the environmental crisis, in isolation, and that in thinking about solution, we are looking, for instance, in the idea that you could just paint capitalism green and it becomes business as usual with green capitalism. But what we need is an overhaul of the system, or rather, the organization of the economic foundations of society. Now, my argument here is that the environmental question is a class question. And in it, in the determination, but also the resolution of that question, the working class, as a social force, remain central to the building of the environmental justice movement and, of course, the possibility of the victory of this movement. You would, of course, have learned from, propaganda of the global elites. And I think also when you think about the fact that, we have shared natural concerns about the fate of humanity because we inhabit the same climate, we inhabit the same, planet. It may appear that we are indeed in this together. But I think the point to make is that we have never been, we are not, and will never be in this together under capitalism. And this is true, of course, of the economic, of the social, of the environmental and climate and every other crisis of capitalism, including the topic under discussion, but also the brutal colonial wars that you are seeing, the inter-imperialist conflicts, and all of that. Because the impacts of every single one of these crises are mediated by the social stratification of society into classes and the oppressive social relations based on race and gender, amongst other markers of oppression capitalism create and perpetuate. Climate, that is to say that, and I think from this logic, as I've said, climate change, environmental crises are not, exception. Their impacts are mediated by the same realities. And I also think that, when you look at the fact that we have really been faced with a growing, climate crisis, but also environmental crisis in every major, country of the world. And this has been brought to the fore of the public discourse, but also of the establishment in various countries or every country and globally. We've not had solutions. And despite the declarations of the conferences of parties, politicians, and corporate spokesperson, our collective, we are not making progress in the resolution of this crisis. If anything, is getting worse. And that is primarily because, in a sense, these are institutions that cannot overcome this crisis. And the reason that I insist that it is a class question, it is because the class determines really who is responsible for the cause of it, who bears the responsibility, and who bears the consequences. And these vary everywhere according to class, but also, the relations of oppression. And I think also this determines the way we should think about what social forces will bring about the resolution, but also what will be the terms of the resolution of this, as with other crises and so on. The point also that I think is important to underline is that, and I think, that the working class, and particularly its, oppressed layers, women, racial minorities, migrants, and all of this bears the main brunt of the ecological crisis of this system. And this because these are people that are already marginalized and degraded by the crushing domination of global monopolies that benefit, above all, the oligarchs in the metropolitan centers of the world imperialism that are owning these global cooperations and rightfully are responsible for the environmental and other crises they cause. But I also think that the working class, we should remember, is not just a victim. It is actively resisting this victimization and brutalization, whatever form it takes, including degradation of the environment. And I think this is what makes the labor perspective on this environmental crisis and the struggle for a right to a clean, health, and sustainable environment significant, because it's not just a question, really, of the revulsion and the resistance against the violence and injustice of this. My argument is that the working class has a power than any other force in society to actually overcome this particular crisis, and any movement that we build that does not have the working class at the center of it would not be able to succeed. And that's because when you look at the working class, and I'm going to, come to this issue of why I think and the role that it played in building the movement. But I think to underline the point that is because the very objective basis of the working class or the oppression of the working class, in a sense, also invest it as a class with the power to resist in a way that no any other social class has, but also a potential for a kind of a change that we need to overturn the logic that is driving us to, to increasingly developing environmental crisis, and especially a climate catastrophe. And this is because the working class is oppressed first and foremost because it is a productive class whose labor creates all value in society. And the point to underline here is that this places the workers on the very nerve center of society, that is the economy and the industry. And this power is evident in the fact that it is a working class and not any other force that has capacity to paralyze partially or completely these, wheels of industry or the movement of the economy every time they act in collective defiance of the bosses as an organized force in the workplace, on the industrial plane, or through a general strike across the economy. But I also want to say that it is also certain, or rather to put it this way, that it's also certain in the logical outcome of this exploitative relationship that the working class is forced to struggle and bring to bear this power in pushing the changes it needs in terms of the environment as it changes it needs in terms of improving its condition on every other major question. But unlike other classes, I mean, I'm a middle class person, a lawyer who can decide to struggle and so on. But the very condition of the working class is that they have no choice but to struggle, because for the working class to exist is to resist, because their very survival depends on that resistance. And despite the fact that the struggles of the working class, the movement, the power, has been, of course, written, of by and large, particularly in the history of the environmental justice movement, we should remind ourselves, and I think the participant in this conversation, that all the positive elements of the modern civilization are not, the natural advancement in human reason, wealth, and the productive power of society. Indeed, all the rights and the protection we cherish today, including the universal franchise, freedom of assembly, association, healthcare, education, social security, leave days, and indeed the right to a clean, healthy, and sustainable environment were the conquest of class struggle and the organized working class. Not a single one of these rights were considered without a bitter and bloody struggle. For each and every one of them, the working class paid in blood, sacrificed their limbs, broken bones, and countless martyrs for us to be where we are today. And I think this is important to keep emphasizing, because it is very easy if you're a young person entering the movement today to think, well, the labor movement is a spent force, the working class is irrelevant, because the policies pursued by their leadership in many instances has been to counterpose the interest of the working class against the interest of the struggle for environmental justice. And I want to argue that those interests are not irreconcilable. If anything, the right to environment, the right to a clean, healthy and sustainable environment is a conquest of the working class, is the right that has meaning to the working class than any other class, because where you have squalor, where you have pollution, where you have degradation, it is a working class that bears the main brunt. And I think to say that, as I've already made the point, that the working class, with the capitalist class are caught up in this logic of the struggle and the social relation that neither of them can get out of or wish away. And therefore, for the working class, the existence means resistance. The same thing can be said that unlike, or rather, part of the problem for many of the environmental justice movement in despairing about the role of the working class is to think that actually we could make sense with the capitalist class and somehow get to a point where they understand the gravity of the situation and by implication begin to correct their ways and of course be able to organize society in such a way that we are able to overcome the current crisis of the environment and so on. But I think what they're missing is that this is a class which, or rather, whose very basis of existence is a system of capital accumulation that depends on the exploitation not only of the workers, but also of the environment as a matter of necessity for the organization and advancement of the economy. To put it differently, the accumulation of capital and corporate profiteering by which it is attained is an organizing principle and the motive force of the political economy of capitalism. And the capitalist class, the employers, the political parties that govern our countries, their governments, both nationally but also institutions that are extensions of it globally, are personification of the logic of this accumulation that created the crisis of environment, that pit humanity against the environment, and therefore they're incapable of bringing solution. And I'm underlining this point to make the point that there is just no substitute for us to build within and amongst the majority of the working class people who suffer the consequences of the environmental crisis, who or for whom, and only for whom in the most instances, the right to a clean, healthy, and sustainable environment has a real meaning in their day-to-day lives. But also that these are the power, people who by their numerical strength and of course their location, in the economy have, of course, the power to change. This crisis of climate, or let me put this way, that I think I've already made a point that the capitalist class can't get out of this crisis, but also to make the point that the whole architecture of their national governance and geopolitics not only personify the systemic logic of global capitalism, which is constant accumulation, imperialist plunder and dispossession of labor and neocolonial people, but also the pollution of environment and climate. That the task rests with the working class, as I already mentioned, and this class has a power. And I think this power, perhaps to conclude on this note, or rather on this point, is best summarized by the Marxist, the British Marxist, Ted Grant, when he says, not a wheel turns, not a phone rings, not a light bulb shines without a kind permission of the working class, Once this enormous power is mobilized, no force on earth can stop it. And I think for me, this is a very important point to make as we go into the history, really, of the environmental, of the struggle for environmental rights and justice and the labor movement. And in this context, it's important to underline this point, that the environmental crisis, it took many forms, but itself is as old as a system of capitalism itself. because soon after capitalism unleashed industrial revolution, pollution and degradation of the environment emerged. It was on this basis that the pioneers of the workers' movement began to take the rights to clean, healthy, and sustainable environment up. Organized labor movement began to take the question of environment up precisely because they recognized that environmental degradation and pollution is a crisis being showed us by the workers and the working class broadly. The studies, the historians of the environmental justice movement have always been biased in their focus of the bourgeois legal and political reformers and their efforts for conservation of pristine wilderness in their study of the history of the environmental justice movement. But I think these studies fail to appreciate that the most important struggles over environment, as we understand them today, were waged by the working class people, and particularly its oppressed layers of racialized and gendered labor. And it was these struggles that forced the matter into public discourse, and the reformist wing of the political establishment sought accommodation and compromise to maintain the stability and began to enact measures that led to current legal development which recognize this as a right in national and international law. And I think this is also evident, if you like, that in the fact that every major revival of the environmental justice movement everywhere has been linked with an explosion of the working class struggle. And I mean, to give an example, when I was researching on this, I looked at the history of the environmental justice movement, in the US, they trace it. They trace its origin from the civil rights movement. But also that beside the civil rights movement, which was obviously the movement of primarily the Black working class fighting the racial discrimination and oppression in America, it was also the Black workers who waged wildcat strike and forced trade unions to face up the neglect of the toxic chemicals that killed workers and their communities in Detroit in 1978. In 1968, that was an important milestone in, of course, reforging or tying of the historic knot between the struggle for workplace justice or labor justice, if you like, and the struggle for a right, for a clean, healthy, and of course, a sustainable environment. In South Africa, it's no different. If anything, is borne by more of a recent history of the environmental justice movement as we have today. The current environmental justice movement rests primarily on the mining-affected communities, which exploded in mass strike movement that took place in 2012 after the massacre of the Black mine workers protesting the poverty wages, failure to provide housing development, and squalor in the informal settlements where Black mine workers are staying. This is also true of the past of both the workers' movement, but also environmental justice movement in South Africa. As soon as the environmental crisis began to emerge in urban centers and countryside with the advent of industrial revolution, so did the struggle of the working class for environment. And I think that is because the mechanization of production and horrific conditions of work and living in new factories and minefields were hazardous to the workers, first and foremost. And hence, the workplace safety and health became the standard cry of the emerging trade union movement around the slave wages, long hours of work, and child labor at the beginning of the workers' movement in the, in the 19th century in particular. But these struggles in the workplaces for health and safety measures also went parallel with the struggles of the working class communities against pollution of water, air, and land from industrial emissions, waste, and raw sewage in many major urban centers in Europe at the very early beginning of industrial revolution and, of course, of capitalism itself. Lots of these efforts are written out of history. But if any person come or rather apply his mind, nowhere has the working class ever got improvement in the conditions either of work or of life, and the right to a clean environment is no exception, other than by means of struggle. It had never just occurred to the capitalist class and its political establishment that they must improve the conditions of the working class at the expense of their profit, without struggle compelling them to do so. The issue did not just end with the issues of workplace struggles, but also the community struggles against pollution of water, air, and land through emissions and waste. Working class people organized increasingly in trade unions, right in the very early beginnings, of the 19th century, but also of the 20th century as well, began taking up in their communities public health issues along other demands for public services. I mean, the pile up of rubbish, the spillage of industrial and chemical waste, running of raw sewage on streets in urban centers were taken up by the activists and campaigners in affected communities before they were taken up by liberal reformers that they petitioned. Whereas the focus has been on the efforts of these reformers, again, as I've underlined, many of the efforts, the protests, and the struggles waged by many working class people and activists have been written out of history. And of course, this is true of the past, but also even today. I mean, when you look at the studies of the environmental struggles in this country, that is South Africa, that's where I am, you would think for a second that it's NGOs that are engaged in litigation, is, NGOs that are working on questions of environment, of climate, that are actually moving and forcing the political establishment to make changes in this respect. And I can say, not only as a labor activist, but as an environmental lawyer myself, as one of the people in the NGOs whose work I respect and cherish, and I've given my life to it, I can tell you that it is the struggles, the organizations, the movement, the power of ordinary mining-affected communities who are protesting pollution and degradation of the environment. That is the reason that politicians even entertain our efforts and our petitions as NGOs that represent these communities. It is not us who rest with this power. It is, of course, the people that we represent through their struggles and, organizing and, of course, movements that have the power that the politicians and mining corporations are scared of, and is that power that compels them to engage with us and occasionally concede improvements in the regulations and, of course, in the standards of environmental compliance required, particularly of the mining and other polluting industries. As I was saying, in communities, or rather let me say that it is also these very struggles that laid the basis for the creation of the public infrastructure and services for protection of the environment and public health that are responsible for a lot of improvements and, of course, a realization of what minimum standards and rights many working class people enjoy today insofar as the right to health is concerned. I mean, the public healthcare, the public housing, the municipal services that we take for granted today, each and every single one of them were not a clever thought of some liberals in parliament in the past or today. It was a struggle which, as I've said, the working class paid the working class paid a heavy price, many times, often a price, of lives and blood, which is true today in South Africa as it was in the past. I mean, the very fact that you could have a democratically elected black majority government drowning the struggle of the mine workers, demanding not only semi-decent wages, but also just improvement of their living conditions, which currently is squalor and degradation in informal settlements that make majority of the mining communities, is indication of what it takes to have these changes. It was only after Marikana massacres and the massive struggles of communities that we have seen even a conversation in a public discourse, recognizing that there is a need to improve the conditions in the mining communities. And of course, some funds even being allocated. 50 billion rand, I think, was allocated in what came to be known as revitalization of distressed mining towns program by government. But as soon as the movement died down, that money disappeared. Again, this underline that is only on the basis of organization, of unity, of struggle, that the working class attain these rights, and these rights remain as long as they are able to defend them with the same organization, with the same struggles, and the same power. And I think this, for me, it is important in appraising what has historically been the relationship between the workers' movement and the struggle for environment, because I've seen many people almost writing off the working class simply because the working class did not go about taking their struggles as environmental justice. I mean, many mining affected communities fighting the devastating legacy, environmental legacy of mining in this country, would not even know the term environmental rights, but many of them are up in arms against the dumping of the mining waste in their community. I mean, in the province of South Africa where I'm located, Gauteng, which is part of what is called Witwatersrand. I mean, it's a basin that, in actual fact, I think contain 45%, or rather from which was produced 45% of gold in the whole of human history. But I think what many people do not understand is that a lot of this gold here occur a lot with, or rather the ore body occur a lot with a very toxic, chemically toxic, or toxic chemicals.
Excuse me, Mametlwe.
Well.
The French translation is audible to the English speakers. So that should be corrected. I'm sorry. Go ahead, Mametlwe. Sorry.
Okay. That the lot of that ore body, I think it was said that for every 1 gram of gold, there's 20 grams of uranium, just to give you an example, which is chemically toxic and radioactive material. Currently, as we speak, there is 600 kilometers, I think over 100 kilometers of that mine dump, which contain about 600,000 tons of chemically toxic and radioactive material that has created a disastrous conditions for many of these communities. But many of these communities are not taking line low. They are fighting. And most of the struggles obviously takes the form of compelling government to clean their environment, but also providing a decent public housing away from those toxic mine dumps. And all of that, for me, are the essence of the struggle for a right to a clean, healthy, and sustainable environment. But also think that there's not just, to give you a sense, I mean, the very fact that the major theoreticians of the workers' movement took up the issue of environment is indicative of how this issue was really very significant to the workers' movement from the very beginning. I mean, we could take as an example Karl Marx, whose whole science was devoted basically to the struggles of the working class, who followed the advances in science, particularly from an agro scientist, is it Justus von Liebig, who theorized on what he called a metabolic rift, or theorized on the environmental crisis of 19th century capitalism and industrial revolution, and spoke about what capitalism and in its industrial revolution created as a metabolic rift between the modern society and its natural environment. And it is this grappling, or rather, theorization of the environmental crisis that was integrated in the analysis of the broader crisis of capitalism, but also on the program for the movement to organize society on a regional basis and management of production in a way that is sustainable from the point of view not only of satisfying the requirements for food, clothing, and all of that, but in a way that makes human society sustainable. You could argue that this was not really just true of advanced capitalist countries where capitalism originates, countries in Europe and so on. The neo-colonial world as well. I mean, the anti-colonial struggle, for me, was the most profound, environmental justice movement. Because whereas many colonial people would have appreciated the advances that, capitalism and colonialism that brought with it in many ways entailed, they also saw what was actually happening in what enclaves of urban and industrial development was taking place. And that was evident here in South Africa. And for that reason, they've resisted ever since. The logic of capitalism is cooperate, profiteering, and plunder, not only of communities, not only of land, but also of the environment that create the degrading conditions in which many working class communities live to this day. And these struggles almost continued uninterrupted. I mean, when we think about South Africa, for instance, many of the tribal people, if you like, who were defeated in the struggles of, or rather in the wars of colonialization, on being conscripted to the mines, one of the first things that they resisted was the living conditions in the mining towns. And one of the reasons that you had to have, if you like, from the point of view of the capitalist class in this country, you have to have apartheid and its compound system of a single-sex male hostels in which mine workers were actually being kept and forced to stay for duration of their contracts, is because mine workers refused to stay in those hostels. And when they were forced They resisted, and every single movement of the mine workers took up the compound system and, of course, the horrific and degrading conditions of squalor and disease that it entailed. If that is not a struggle against or in struggle for environmental justice, the right to a clean, healthy, and of course sustainable environment, I don't know what else is. But I also think that, and I'm going to try to move towards the conclusion, or rather summarizing this point, that, and I think that's a point I'm trying to make, that for the movement in the beginning, right, the struggle for clean environment was just a logical extension of the worker struggles on every other issue and crisis capitalism in its beginning, in its development, but also in its monopoly stage created for the working class. That was true then, but also is true today of many ordinary working class people. It is only, of course, trade union bureaucrats who have been co-opted over a period of time by corporate interests in the economy. They've been co-opted ideologically into the idea that economy and therefore the interests of the working class are best served when, the capitalist class are making profits, that the interest, the economy and the interests of the working class are best served when, the corporations, their shareholders and investors are making major profit that have created a rift that has developed currently between the trade union movement and the working class broadly and the environmental justice movement. But I think that subversion and corruption of the working class and the trade union movement has also been paralleled by the subversion and corruption of the environmental struggles, or rather environmental activist movements, if you like. Because what the capitalist class does, first, they respond with suppression of the movement, of the working class, of the oppressed people. And when that repression does not or no longer yields any meaningful benefits, they combine it with co-option. And I think we've seen this time and again. And I think in the trade union movement, it produced the result that it has, which I think many knows, where many trade unions are counterposing the interest of workers to the demands of the environmental justice movement. But also in the environmental justice movement, it has produced a similar phenomenon where environmental, if you like, activists have aligned themselves with a corporate agenda and think that by demanding less, if you like, not doing the hard work of linking with the workers, if not through their official trade unions, also with the rank and file, they've taken an easy route of course, confining their activity to lobbying corporate interests, and in it, many of them willingly accommodating themselves to their demands for green capitalism, if you like. And I think for me, that is the rift that we must overcome. And to overcome it is to really recognize where this rift came about. Now, I'm going to skip this section, but I think the point to make is that despite all of this, the working class continue to struggle. And I think in many countries, but also international today, the right has been won. And I think the previous speaker has, thoroughly analyzed what that right entails. Safe to say that the Stockholm, Conference on Human Environment, 1972, signified an important moment when the right to a clean, healthy, sustainable environment received recognition. But the point that I want to underline is that, the right that this right, that it was a product of the struggle. It's not coincidence. It's evident from the fact that it was Sweden, if you like, the period when it was, a social democratic state with, or rather, governed by a party rooted in the working class, a social democracy that initiated that conference. But also, it was Portugal, the first country to domesticate the right to a clean, healthy, and sustainable environment in 1976. That is 2 years after a revolution of 1974, when the whole of the Portuguese society was in ferment, in revolutionary ferment at that time.
Mametlwe,
And I think
have to
I'm
wrap
citing
up
this
now.
example
Yes.
to underline the class character of this. And this rise obviously means that, since then, rise has been further developed, but also it has now been recognized in over 155 countries across the world. In many cases, not just because the establishment decided to domesticate the laws, but because of the struggles from below. And just to say, maybe in summary, as I conclude, that despite the advancements in the regulations of workplace health and safety, as well as environmental standards for human settlement and industrial development, compliance everywhere has been receded by corporate interests. In many neo-colonial countries, this legal framework do not even exist. These areas are still treated by big multinational corporations as slave colonies for plundering of minerals, enslavement of local populations in extractive industries responsible for most greenhouse emissions and pollution. And I think also that it's for these reasons that we must understand that the struggle is continuing and we need to build, but in building, we need to understand that the solution is not going to be brought about just litigations, lobbyings, of cops, of government, and of big corporations, but of building the movement whose power will be able to force the changes we need in terms of climate, or rather, the energy systems that are polluting the climate, as well as, of course, pollutions of environment in general. And I think, this, for me, requires that we think not only about this history, but also requires that we learn the lessons from there. There were unions that in the past did play an important role. An example that I think I found in the context of the US was an oil, chemical, and what that union is.
Excuse me, Mametlwe, we're going to have to wrap up because the last speaker
yes.
did not have enough time. So thank you.
Okay, 1 second. That those unions did play a role, but where we are, of course, obstructed by, the bureaucracy of the trade union movement. In the past, activists found ways. The examples of the Detroit, rank and file wildcat strike on the workplace have chemical, toxic chemicals and so on. It's an example of that. But also think that we have an example here in South Africa where the grassroots mobilized on this, but also, as I raised in the Climate Justice Coalition, where today the big National Union of Mine Workers is wedded to the fossil fuel and coal mining interests. There is an opportunity for us to mobilize on the shop floor by linking the climate justice and struggles, environmental justice movement with the struggle for workplace health and safety. Because coal is not only polluting the climate and damaging the public health, is a health hazard because sulfur it contains is damaging the health and killing the workers and people in communities. And I can see how any union bureaucrat will stop mine workers from joining any case and a movement that seek to demand compensation, justice, and movement away from their thing and so on. So for me, that's an example of how we can be able to build to circumvent the bureaucratic obstruction to fusion, or rather tying of the knot of the link between the workers' movement and environmental justice movement. Sorry, and my apologies for going on like this. Thank you.
Thank you so much, Mametlwe, for pointing out how the climate crisis is part of the broader crisis of capitalism and the centrality of the struggle of the working class. Our final faculty member who will address you is Richard Harvey. Richard?
Sorry. Thank you, Marjorie. Thank you, Mametlwe, and thank you, Marty. This has been already a very full discussion. And so, greetings to all of you out there from Kathmandu to California, from South Africa to North America. We've got a large number of people who showed up. I hope some of you have still got the energy to stay the course. And I'll try to abbreviate my words, but if I could have my slides up on the screen, thank you. And just to make a mention of Monique and Roland Weil, with whom I worked for many decades since joining the IADL back in 1975. And this is a terrific achievement that you've put all this together. And could we have the next slide, please? Because I've been working as in-house counsel to Greenpeace International, focusing on people's struggles for climate justice. And to paraphrase Mametlwe's comments just now, it's all about the fact that when it comes to the environment, those that cause the least damage suffer the most harm. And we therefore have seen this gradual but inexorable growth of understanding of the importance, the centrality to workers' struggles, to women's struggles, to the rights of all to a clean, healthy, and sustainable environment. And already more than 80% of UN member states recognize this right in one form or another, whether it's in their constitution or in their statutes or through their courts. More than 80% of UN member states. The UN Special Rapporteur on Human Rights and the Environment, Dr. David Boyd, has said that and this is what he said in 2018, so it's probably got worse, every 4 seconds, a human's life ends prematurely because of exposure to pollution and other environmental hazards. This amounts to 800 deaths per hour. It's beyond debate that people are wholly dependent on a healthy environment to lead healthy lives. And the call for the UN to urgently fill the glaring gap in the human rights system has still not been fully answered. Also in that same year, 2018, 27 young Pacific Islanders sitting in a law student's class at the University of the South Pacific decided that it was taking too long, it was moving too slowly, and it was too late to keep on waiting for the UN to come up with a solution. And they said, we need to go to court and we need to take the world's biggest problem to the world's highest court. Could we move on 2 slides, please? Galloping here. Thank you. No, I've gone too far. I'm sorry. Go back 1, please. Thank you. What I've called here the rights place at the right time. There has been no more exciting time to be an environmental lawyer. Now, most people may not think being an environmental law is the most exciting thing to do. But realistically, at this point, wealthy states are trying to claim that there's no legally binding responsibility on them for human rights in the face of climate change. International law and human rights, they say, these just started in Paris in 2015. It hasn't been going on for long. Well, you saw that chart that we had just now. There is a long list of cases and of statutes and of conventions and agreements that go all the way back. Are there rights to climate justice? No, that's not the question. The question is, how are those rights to be enforced? And that only comes through people. It doesn't come through NGOs, doesn't certainly come through governments, and it most certainly doesn't come through corporations suddenly seeing enlightenment. It comes through people. And if we could go to the next slide, please. I was privileged back in 2016 to meet some of the founders of the Climate Senior Women, the Klimaseniorinnen of Switzerland, who formed just a few hundred of them back in 2016. They've now grown to 3,400, and they are all women pensioners. They battled through the Swiss courts where judges ignored their scientific proofs of temperature deaths caused by extreme heat waves. Their Supreme Court ruled that the planet had not yet reached 2 degrees of global warming, so this should be just left to the politicians. The politicians, in turn, blamed the electorate for failing to pass a deeply flawed climate change referendum. So it's not our fault. We gave them a referendum. It wasn't worth much, but at least they rejected that. And so the Klimaseniorinnen said, there's only one choice left. We've got to go to the European Court of Human Rights. And not only did the European Court fast track their case, but they referred it to their Grand Chamber for a full hearing, which took place on the 29th of March last year. And the case that we argued to that court, we said that the world has never seen a threat to human rights of the scope presented by climate change. This isn't a situation where any country, any institution, any policymaker can stand on the sidelines. The economies of all nations, the institutional, political, social, and cultural fabric of every state, and the rights of all people and future generations will be impacted. There's only one way to prevent the 1.5 degree limit from being breached, and that is for global emissions not to exceed the remaining carbon budget. That budget must be shared fairly between states. What did Switzerland say? Switzerland said, we're a special case. You've got to give us a bit more time. We said, giving you more time means you will use up the carbon budget share of other states. That is carbon theft. We said, if a state as rich and technically advanced as Switzerland doesn't do its fair share, taking the lead as well as pursuing its highest possible ambition under the Paris Agreement, then other states will also fail to do so. Well, Switzerland can't do it. You can't expect us to. So could we move to the next slide, please? This is David Boyd, who is the outgoing UN Special Rapporteur. He's been doing the job for almost 6 years now. And he leaves a massive legacy that he and his predecessor, John Knox, have created through that special mandate that they have pursued. And he is today presented to the Human Rights Commission in Geneva his report on business, planetary boundaries, and the right to a clean, healthy, and sustainable environment. And he launches into it by saying the current economic and business paradigms are based on exploiting people and nature. Very much what Mametlwe was just saying. And the human rights of the obligations of states and businesses have to be re-evaluated in the context of the planetary crisis. The scientific evidence is that we are breaching multiple climate boundaries, planetary boundaries. And you see them listed here: climate change, biodiversity loss and species extinction, freshwater disturbance, deforestation, excessive fertilizer use, synthetic chemical contamination, and we're close to exceeding the seventh boundary, ocean acidification. What happens when you exceed the boundary? Well, go back to the days of Columbus when people told him that it was a flat earth, you fall off the edge. Well, this is very much on a round world exactly what is happening, because these may be irreversible tipping points, not something that you can just claw your way back up the cliff. Like Wile E. Coyote, our legs are spinning and we're going off the edge of that cliff. In 2022, the fossil fuel companies made hundreds of billions of dollars in profits, while their products killed millions of people and exacerbated the climate emergency. Multinational food businesses enjoyed record profits, while food prices, hunger, and malnutrition spiked upwards. As David concludes, business as usual is a recipe for climate chaos, millions of premature deaths, forced migration, ecosystem collapse, and human rights violations on an unprecedented scale. I told you I was bringing you the good news today, but this is pretty terrifying stuff to be contemplating. And so let's just move to the next slide, if we may. This recognition that climate harms our human rights harms is basic, but it hasn't fully sunk in. As Marty already said, we have the Int'l Tribunal, the International Tribunal of the Law of the Sea, which is going to deliver an advisory opinion sometime this year on what the obligations of states are for the protection and preservation of the seas, of the oceans. We have the Inter-American Court of Human Rights, which is addressing the question of the duties of states, the obligations of states to protect their peoples against the dangers of climate change. And those 27 students I mentioned took their case to the United Nations, supported by a growing number of core states that realized that we simply cannot wait for the UN for the COP talks to resolve problems. We need a firmer legal basis on which, because judges around the world were saying to us, and we brought cases in many countries, judges said, look, you can't realistically expect us to enforce a human right when it's not expressly written in the Universal Declaration of Human Rights. It's not expressly written in the European Convention on Human Rights. And we cited all of the other treaties, we cited all of the other conventions, but a lot of judges still say, well, that's a step too far. This is up to the politicians. And so when those students said, no, we've got to go that one step further, it was on that same day, the 29th of March last year, as I walked out of the European Court of Human Rights after we presented our case, I got a call saying the General Assembly has just passed, without even the need for a vote, has passed by consensus resolution that they should call on the International Court of Justice for an advisory opinion on what are the responsibilities of states, what are the obligations on all states parties to protect present and future generations from the dangers of climate change and how to protect human rights in that context. So that is a massive, and for the UN and for the courts, that's pretty damn fast work. And I take my hat off to those students then and to all of those who have joined in the struggle since, because we at Greenpeace have been working with communities across the Pacific whose islands are threatened with disappearance. Just think about that for 1 second. It's not simply a question of what are the duties of states, but how do you actually prevent states from physically disappearing from the map and taking their peoples with them? That is an absolutely horrifying thing to contemplate. What we're asking, therefore, is the courts must recognize that climate harms are human rights harms, that the states have the duties to base their actions and their policies on best available science, because we know that the science deniers have been in business receiving massive funding from the fossil fuel companies for decades. And this goes back to the 1960s, that Exxon and others knew full well the crisis that they were creating and perpetrating, and they paid lobbyists, they paid scientists to come up with bogus science and claim that it was never going to be as bad as people like us were claiming. And so states have got to be held accountable based on the international law principles that Marty expounded on in perfect detail. The no harm principle, the duty not to contribute to the extinction of other states. The precautionary principle, that doesn't mean that there's any doubt about climate change. The only certainties are that it's coming, and it's coming fast, and it's coming devastatingly. The only uncertainties are how fast and how soon and how and where will it have its impact first. And it's already happening. The duties of cooperation and solidarity that Marty mentioned, and the principles of equity, fairness, and differentiated responsibility in the light of the respective capabilities of different states. And no, Switzerland, you're not a special case. No, United States, you're not a special case. We're looking for a ruling that states have binding obligations in relation to climate impacts on human rights, obligations of mitigation, of adaptation, and of compensation for loss and damage, to regulate business enterprises, because this is what it all comes down to. So many states have been captured by the economic imperatives imposed on them by business, and state-owned enterprises of the big petro-states, and those include Norway, that simply carry on with business as usual and will continue to devastate the planet unless states are forced to regulate them and prevent them from going down the devastating road on which they are determined to take us. And that states have binding obligations to protect the climate system itself, not just for themselves, not just for the present, but for future generations. And so if we can move to the next slide, please. We need climate justice, not just now, and not just intergenerational, but also intra-generational. that people should not be treated differently because they come from different countries. All peoples have the right to climate justice. And these international tribunals need to hear a deafening chorus from civil society. And that includes the rights of indigenous peoples who are being ignored by the International Court of Justice. Indigenous peoples want to have the right to present their case to the International Court. The International Court saying, no, only states and intergovernmental organizations. We've approached the court. Greenpeace has more expertise than a little when it comes to climate justice. No, you can't submit. So we will be submitting, but we won't be in the courtroom if they have their way. And that is a very serious concern. Indigenous peoples who live across, in many situations, across state boundaries, 3 or 4 different states. One state may actually stand up for the rights of indigenous peoples. The next door state may trample all over them. They have the right to be heard in and of themselves. And climate impacted communities throughout the world need to be heard. So, on the city streets and in the office suites, we demand that they are heard. In the courtrooms and in the boardrooms, we demand that they are heard. We need to challenge those so-called political representatives who fail to represent the interests of their peoples. We need to seize the headlines and we need to beat the deadlines. The next deadline for presentation to the International Court of Justice of our submission is the 22nd of March. We will have our submission in there, as will many organizations and states, and we're looking forward to many of you joining with us in supporting your organizations filing submissions and in keeping the pressure on, putting the pressure on, and being with us outside the court and outside your own political representatives. Places, I was going to say houses, that's a bit controversial right now, but outside their parliaments, their legislative assemblies. Over to you.
Thank you so much, Richard, for explaining planetary boundaries, the climate crisis and chaos we're really facing, corporate responsibility for the climate crisis, and international legal strategies for combating it. The next section of our program was going to be the panelists responding to each other, but since we're very short on time, I'd like to go straight to the audience questions, and perhaps our panelists in responding to those questions can make any comments they would like in response to each other's presentations. First of all, what is the relationship between and accountability for militarism and climate crisis or climate chaos? And the related question is, how do the US criminal violations for sending arms to Israel for use in its genocide against Gaza relate to or intersect with the right to a clean, healthy, and sustainable environment? So those are the questions put to the panel, faculty panel, who would like to respond?
I'll come in briefly. There is no place on earth that is as totally devastated as Gaza. We all know that, we all see that. It is human and environmental destruction with a speed and intensity that hasn't been seen since Hiroshima and Nagasaki. The responsibility of those who continue to provide the weapons is certainly an issue that could be taken up in the courts and should be part of our argumentation. So that's my quick 2 cents on it.
And the other issue that is, I think, really relevant to this discussion is that largely the military emissions and military impact on the climate have been written out of certainly the COP meetings at the demands of the United States, especially. And there's only been voluntary provision of data about military emissions, and this has got to stop. This is military caused carbon emissions are among the highest of all carbon emissions. And the fact that that has affected the entire sequence of environmental meetings and also, I would say, the shaping of the special rapporteur's reporting, because that hasn't come under any of the reporting. And I know that, for example, at COP28, that NATO appears at COP28. It did, and this wasn't the first time, as a legitimate entity, which is, I think, something that also has to be addressed. There's a movement to get rid of NATO. There is a movement also. I know that that comes maybe in part out of the Pugwash movement, but there's a People's Declaration for Peace, for Climate Justice that's come out of this last COP28 meeting to try to change this. And obviously these are not, this is a different and longer term mechanism than trying to get criminal accountability in Gaza, which is another, it needs to be done also. But I do think that we have to take a look at how the whole system has been functioning in relation to military activities, military spending, and so forth.
Thank you, Marty. I did want to mention that the United States Organization of Veterans for Peace has a national project called Militarism and Climate Change. And one of the things that they focus on is PFAS, P-F-A-S, which are toxic chemicals made of fluorine, carbon, and hydrogen, forever chemicals that the military is responsible for permanently inserting into our environment. So people can go to Veterans for Peace, the website, and there's a tremendous slideshow and all kinds of documents and reports on militarism and climate change. Mametlwe, did you want to respond to that particular question?
Well, look, for me, I think insofar as the litigation of rights, and especially in the context of environmental rights, especially in the context of the war situation, the only thing that I would say is that, look, there's always a merit in terms of, using litigation strategy, but which strategy is subordinated to a political strategy, which I think for me, is where the power lies, is where we could get the power really of people who, instead of becoming a bystanders, observing, from a distance, lawyers arguing and squabbling about technical issues, they could be able to participate. And we've engaged in litigation like that even here. But at the same time, I think we should also be absolutely clear. The court systems are part of the political architecture for the governance of the system that is responsible for this crisis. And I think when we think of litigation, we've got to think about the fact that rights established in law, conquest of class struggle, as I've said, they are, but also they never really supersede the economic and legal foundations on which they rest. And in a context where really we're living the age of empires, court system, both domestically and internationally, they are part of the imperialist system. And you can see in terms of even what is happening at ICG, International, Court of Justice, with regard to what is happening in Gaza, where the court itself really, for me, has been on trial. And they've just been navigating on how they can, if you like, maintain the credibility in the court of world public opinion without really offering the suffering people of Palestine a remedy in a form of a clear and unequivocal order of ceasefire. So we've got to be careful of the limitation of the law. We've got to be clear about the role of the courts. At the same time, I think they can be used skillfully to build a movement and, of course, to educate as well, where we're clear that the strategy is not so much really to just argue over technicalities, but to use the cases to educate and to clarify issues on the basis of which could build a movement and mobilize people.
Thank you so much for that comment, Mametlwe. As we used to say in the 60s, one struggle, many fronts, and certainly the legal tools are only one aspect of the struggle. And of course, they are meaningless without the context of the people's struggles. As we all know, millions of people have marched in the streets in support of the Palestinian people and demanding a ceasefire. And there is a great deal of frustration in the International Court of Justice issuing provisional measures, telling Israel not to commit genocidal acts and to allow humanitarian aid, and Israel thumbing its nose at the court. But one thing that has been very, very effective is with these hearings is what we call the mobilization of shame. The United States has been shamed in the eyes of the world for its assistance and complicity in genocide. Israel has been shamed in the eyes of the world for the most transparent genocide in our lifetimes. And so, again, we need many, many tools. And as lawyers, as environmental lawyers, as activists, as human rights defenders, we need to call on, we need to use all of these particular tools. We have another question, and that is, what is the impact of technology, mechanization, and artificial intelligence in promoting the right to a healthy environment?
Maybe I should take that. Look, I mean, technologies, or rather advancing technologies, have also really been subject of contestation, and they've always been determined in the course of the struggle themselves, because obviously under capitalism, they have been weaponized. For the capitalist class, technology is not really about improving the workplace in the interest of workers and the working class people and society at large. It is about accumulation of more profit. And we see it here where, for instance, lots of these technologies are used, or rather employed, to carry a brutal restructuring of the industries that leave, for instance, many workers out of jobs. But even those few that, remains at work, they are employed, at a frantic, nerve-breaking pace that is responsible for a lot of, mental health problems and pandemic. I think that's the only way you can describe what is happening to many workers in these, fast work industries, if you like. So at the same time, obviously, lost in, technological advances, including artificial intelligence, is really possibilities of improving the quality of work, and by raising the productivity of labor, productive capacity of society, by really, raising the standards and quality of living. But again here, these are questions of the struggle of living class forces. The capitalist class is not going to invite us to the banquet simply because it has increased wealth. We're going to have to organize, we're going to have to unite, we're going to have to fight for every single share of that increased wealth of society if we're to improve our lives in any meaningful way.
I would just add to that, if I may. One of the quick fix technologies that states are constantly talking about and saying, we don't need to worry about this. We'll have carbon capture and storage. We'll have put up some great mirror in the sky. We'll all kinds of wonderful technologies which don't exist at scale. But they use this constantly as an excuse for doing nothing whatsoever in response to climate change. And so, yes, be absolutely wonderful if we had technologies that A, were not oppressing the working class, and B, were actually addressing climate change. But the simple word from here is don't hold your breath.
And I'd just like to add that an example of this, of a technology that's not available, but which is being offered as a solution, is the small module nuclear reactor, which this past week the U.S. the House, either the House or the Senate passed by an overwhelming majority a bill to fund exploration. This is not a solution, and it's obviously designed to further militarize U.S. politics. So it's the technology can be used both to defeat the right to a healthy environment and the right to peace.
We have another question, and that is criminal and civil accountability of corporations, and I would add, and governments for climate chaos. And I did want to mention one thing, and that is that there was a very significant case in the United States, the state of Montana, a case brought by youth plaintiffs against the state of Montana, and they won in the court. In August, they secured a victory where the judge said that this was that not taking climate chaos, climate change into account when issuing fossil fuel permits violated Montana's constitutional right to a clean and healthy environment. And in addition to the European Court of Human Rights case involving Switzerland that Richard talked about so eloquently, there is litigation in countries, in states that hopefully will have some impact. And I also just wanted to briefly call people's attention to the Merchants of Death War Crimes Tribunal that some of us are associated with, that is holding hearings and videos. Merchants of Death is the name of the website, and drawing the connections between the war corporations and the weapons that are killing people in Gaza and all over the world. So at any rate, the criminal and civil accountability of corporations and governments, if anyone wants to comment on that.
If I could come in quickly on civil accountability, there's the case of Milieudefensie, which is environmental defense in Dutch, against Shell, which was a very successful case against Shell, requiring them to do what they have never done, which is to disclose the environmental impact of all of their products globally, not just in the Netherlands, because we all know that the environment doesn't sit neatly on top of the country where the greenhouse gases are emitted, but they very uncomfortably overflow around the world. And therefore, businesses have to be held to account for what are called their Scope 3 emissions, the emissions that come about from combustion. Shell very conveniently only wanted to talk about the emissions that came about from extraction, which are something like 3% of the total emissions caused. So this was a great victory. And of course, Shell is appealing. But that's one important thing. The other thing I think to focus on is that environmental crimes are things that get us all strongly energized, but they are very hard to prove. They take a very long time to bring to court in the first place, very much like the International Criminal Court, where cases take 20 years or 30 years from the date of commission to the date of conviction. And so it's a bit illusory, I think, to go after crimes that we all think should be criminalized and should be crimes. But there are various areas, though, like greenwashing, which can amount to fraud. And so depending on your jurisdiction, depending on what your local laws have, even bringing a case can make the corporate directors a little bit uncomfortable. It doesn't mean they get dragged into court in chains, much as we might like to see that, but it does mean that you help to frame the case in ways that they find uncomfortable. You take away their civil license to operate. Over.
Well, thank you so much, Marty, Mametlwe, and Richard, for your compelling presentations, and they will all be posted within a few days on our website, peoplesacademy.net, along with other resources that people can use to delve more deeply into these issues. And we hope to see you all on March 21st for Seminar B, The Illegality of Unilateral Coercive Measures. Thank you all for attending, for registering, and for the interpreters, for Charlotte Cates, who without whom we could not put on these programs, and we look forward to the next one and the following ones, and we look forward to seeing you all. So thank you so much.
Thank you, Marjorie. Thank you, everyone.
Amantla.
Gawetu.
Oh, you know, Richard.
Lucha continua.